this is Sam Spagnola at the Spagnola Law Firm in Greensboro, North Carolina. I'm going to spend a few minutes with you today talking about equitable distribution of property. Well, what does that mean? That simply means how the court divides property when a couple separates, a married couple separates. And that's important because if you're not married, the equitable distribution laws do not apply to you. So there are three categories of property that the court has to consider in an equitable distribution. The first one is the marital property itself. Well, what does that mean? Well, marital property is defined as all property acquired between the date of marriage and the date of separation. That can be real estate, it can be cars, it can be personal property, furniture, it can be stocks and retirement plans, which are often overlooked by people until they talk to a lawyer to help understand what that really means. For example, you might have a 401k that you were putting money into before you got married. Then you get married and you keep putting money in that 401k. Well, the money you put in the 401k before you got married is your separate property and is not subject to being divided by the court. However, the contributions you make while you're married and the gains or losses on those contributions during the marriage are marital property and can be divided by the court. So that applies to all types of investments that you might have. If you contribute to it while you're married, then the contributions and the gains and losses on those investments or retirement plans are marital property and subject to being divided. So it also doesn't really matter whose name is on the account. People often say, well, this car is titled in my name. Well, if the car was purchased while you were married, it doesn't matter whose name the car is in. It's going to be marital property under the marital property laws in North Carolina. Real estate is a little different. If you acquire the real estate while you're married, just like anything else, it's going to be marital property, whether it's titled in your name or your spouse's name. If you had the property before you got married, there is going to be a marital interest in that property if, for example, you were continuing to pay a mortgage on that property while you were married. Those mortgage payments that you make and the increase in equity in the house as a result during the marriage are going to be marital property. So whatever equity you had in the house before you got married is going to be your separate property. But the increase in equity as a result of making payments on the house during the marriage is marital property. And so even though your spouse may not be on the title to the property if you had it before you got married, they still may have a marital interest in that property. Now, obviously, if you buy it while you're married and you title it jointly, it's going to be marital property. And even if you bought it while you were married and didn't title it jointly, unless the spouse were to sign a waiver, it's still going to be considered marital property. And the second category of property is separate property, which pretty much is every other property that you had before you got married and after the date of separation, where there's no marital contributions to that property. Now, that said, we can get into some complications where you can take some separate property and convert it to marital property by using that money to acquire marital assets that are not reserved as your separate property. In other words, using separate property to acquire marital property can be construed as a gift to the marriage in some circumstances, and you could convert that separate property to marital property if you don't do that correctly. And you find yourself in a bad position of where you were expecting that you would get your separate funds out of the property division, and you don't. But basically, again, separate property is all property you acquire before you get married or after the date of separation. Those would be considered your separate property. Now, there's a third category of property as well in North Carolina, which is called divisible property. Divisible property is simply the increase or decrease in value of marital property that occurs after you separate. So, for example, the value of your house, you separate in January and then your property doesn't actually get divided till November. Well, the value of your house in November is going to be different than it is in January. So that increase and decrease in the value of that property is also subject to being divided. Same as with stocks, which is probably more common. The value of your stocks fluctuates daily. So on the day you separate, the marital value of your retirement plan or other stocks you hold may be one thing, but by the time the court gets around to dividing it, those shares or the marital interest in that property is going to be different than it was on the day you separated, and the court can go ahead and divide that property as well, those gains or losses as well. Another thing I don't want to overlook on this is debts, marital debts, debts that are acquired while you're married. Doesn't matter, generally doesn't matter if it's in your name or your spouse's name. Those are considered marital debts. Now, there is a caveat there as well. Our rules say that a credit card that's taken out in the name of one spouse is presumed to be the separate debt of that person, unless the other unless that spouse can show that the debt somehow benefited the marriage or was for a marital purpose. So if you have a credit card that's in your name only, and you and your spouse go on vacation and charge that card up, there's a good argument for you to say that your spouse ought to share in that debt because there was a benefit to that spouse. Or same thing if you're going out to eat and using that card, or buying clothes for your kids with that card, then that can be considered marital property in form of a marital debt by the court and be divided between the two of you. Now, let's just say, one of the concepts of marital property is there's a presumption under the law that everything should be divided equally. However, that's not a requirement. There are factors that the court can look at and determine that dividing everything 50-50 is not fair. Now, I'm not going to get into all those on this video. We really don't have a lot of time to do that, but there are a number of factors that the court can look at to determine whether or not a 50-50 division is equal, and you would need to discuss, with your attorney whether whether any of those factors would apply in your case if you're trying to get something other than an equal division. And finally, one thing I'm going to point out, because I get a lot of this when people come in my office to meet with me to talk about property division in the event of divorce, fault does not matter in property division. And what I mean by that is, if someone is having an affair or was mean to you or whatever, was a bad person to you, that does not have anything to do with how the court divides your property. A court cannot give one spouse more than the other spouse because they think that one spouse had an affair or there was domestic violence or anything, any form of bad behavior that's not economic. It just doesn't matter. And some people think that's not right, it's not fair, and maybe it's not, but that's the rules, that's the way it is in this state. So you can wish for it all day long. The court's not going to hear what a bad person the other party was in a property division case. The only exception to that is what they call marital waste. And what that means is, if you have a spouse who's basically gambling away all of your money that's earned during the marriage or wasting your marital assets in some way, that is a bad behavior that a court would consider in deciding whether to divide everything 50-50. But notice that's related to the economics of the parties. It has to be some sort of waste or dissipation of marital assets for that behavior to be considered as a factor in the division of property. So anyway, this, again, is not intended to be a full in-depth explanation of marital property or equitable distribution in North Carolina, but I hope it gives you some overview of the issues that you would be encountering in your equitable distribution case. And when you do meet with an attorney, hopefully a little armed with some more information to understand some of the concepts that you may discuss with that attorney. Anyway, I'm Sam Spagnola. I'm a board-certified family law specialist. My office is in Greensboro, North Carolina. And I thank you for watching the video. And if we can help you out, you can give us a call at 336-373-8469. We look forward to serving you. Thank you.